Welcome to This Explainer. Listen, if you're a legal professional, a litigator, or a scholar of Indian jurisprudence, you already know the landscape of your practice is undergoing a literal earthquake. Today, we're going to break down the structural and operational transition from the 1860 Indian Penal Code to the 2023 Bharatiya Nyaya Sanhita, the BNS. We're treating this as an executive briefing, zeroing in on the precise legislative shifts you're going to be dealing with in court starting July 1, 2024.
Here is a quick look at our agenda for today. We'll be moving through the structural transition, the prioritization of crimes against women and children, new offenses like terrorism and lynching, key repeals, the modernized punishment framework, and finally, the definitive repeal itself. Let's get right into it.
Just take a look at the sheer scale of structural optimization on your screen. For generations, we've all navigated the sprawling 511 sections of the IPC. Well, the BNS streamlines all of that down to a highly consolidated 358 sections. And this isn't just about deleting old laws. It's a fundamental reorganization meant to reduce redundancies. It's going to completely alter how you draft your next charge sheet or defense brief. To put that into perspective, we are witnessing the total replacement of a 160-year-old colonial legal framework. Since 1860, the underlying philosophy of Indian criminal law was rooted in a Victorian-era mindset. This transition to the BNS, it represents a massive attempt at the Indianization of the law, shifting the fundamental objective of the code itself. And that brings us to the core objective behind the BNS, stripping away that colonial mindset to make Indian justice more timely and, honestly, more citizen-centric. The focus is explicitly shifting away from purely punitive state control toward a modernized system designed to deliver justice efficiently. For you as a practitioner, this means the teleological interpretation of these new statutes by the bench is probably going to lean heavily on this citizen-centric intent.
All right, Section 1, the BNS Structural Transition.
Mark your calendars for July 1, 2024. From that date forward, the IPC's 23 chapters are officially replaced by the 20 chapters of the BNS. Basically, your entire working library, your reference points, and your foundational precedents will need to be completely remapped to these 358 sections. This is the new operational reality for every single criminal court in the nation. Moving on to Section 2, prioritizing women and children. So by moving these offenses from the later chapters of the IPC, where they were kind of relegated to chapters 16 through 20, right up to chapter 5 of the BNS, the code is signaling an immediate structural priority for strict and swift punishment. The legislative intent here is absolutely unambiguous. The state is prioritizing these specific offenses at a remarkably high level within the statutory architecture itself. So, how are penalties for crimes against minors actually changing? This brings us to a highly specific and critical operational shift that's going to immediately alter precedents, especially in special courts dealing with vulnerable victims. Check out this vital age shift in Section 70. Under the old IPC framework, a critical threshold for certain aggravated penalties in gang rape cases was 16 years of age. Well, the BNS explicitly raises that threshold, universally defining a minor as under 18 for these horrific offenses. This is a game changer because it completely rewrites the evidentiary stakes regarding age verification during trial, and that leads right into the strict enforcement of mandatory minimums. Section 70 dictates that the gang rape of a minor below 18 now absolutely necessitates either a mandatory, rigorous life sentence, and that means for the remainder of the convict's natural life, or the death penalty. It effectively strips away judicial leniency on the baseline sentence. Defense counsels, you're going to have virtually zero room to argue for lesser imprisonment terms in these specific convictions. Let's move to Section 3, new offenses, specifically looking at terrorism and lynching. Now, if you're a senior legal professional, this table is absolutely paramount. It clearly maps out the exact new sections and severe penalties you're going to be citing. Mob lynching is now formally recognized with a special section, carrying penalties from 7 years all the way to the death penalty. Organized crime, so we're talking kidnapping, robbery, extortion, is explicitly codified in sections 111 and 112 with 5 years to life plus a fine. And crucially, terrorism gets a clear statutory definition right inside general criminal law under section 113. That carries 5 years to life imprisonment or the death penalty. You no longer have to rely solely on separate special acts. The whole shebang is integrated into the primary penal code. The BNS also directly tackles the mechanics of group violence. Section 190 firmly establishes that shared intent within an unlawful assembly equates to shared culpability for the resulting crime. The source material gives a really stark example. If a crowd throws stones to fulfill a common purpose and someone dies, even if it cannot be proven whose specific stone caused the fatal blow, every single member of that assembly can be tried for murder. That dramatically lowers the evidentiary burden for the prosecution in mob violence cases.
Okay, Section 4, repealed provisions, and the sedition shift. We are seeing a definitive shift on this front. The colonial concept of sedition under 124A of the IPC is officially deleted, but it is strictly replaced by Section 152. Now, this new section focuses impartially on acts that threaten India's sovereignty, unity, and integrity. So while the actual word sedition is gone, the statutory mechanism to prosecute acts against the state is very much retained and redefined. This is for sure going to require some careful constitutional scrutiny in future litigation.
You're also going to need to heavily update your legal library to reflect modern societal norms. Section 497, covering adultery, is deleted, officially making it solely a civil matter for divorce, not a criminal one. Similarly, Section 377 regarding unnatural sex is removed, which fundamentally alters civil rights litigation going forward. Though it's worth noting the sources point out this actually leaves no special provision for male or transgender victims of sexual assault. Also, archaic colonial provisions like the thug laws under IPC 310, those have been entirely wiped from the books. Let's shift gears to Section 5, the modernized punishment framework. Section 4 of the BNS lays out 6 specific types of punishments available to the judiciary. You've got the death penalty, obviously reserved for the most heinous crimes. Life imprisonment, which explicitly means the remainder of the convict's natural life. Standard imprisonment, which can be rigorous with hard labor or simple. You have fines, the forfeiture of property acquired by or used in a crime, and finally, a completely new addition to the list. And this is a big one. We see the formal introduction of community service. By explicitly listing this under Section 4, the BNS gives judges a brand new modern tool for penalizing minor offenses. Guys, this is a massive paradigm shift from purely retributive justice to a framework that actually embraces restorative justice. For defense counsels out there, this opens up an entirely new avenue for plea negotiations and sentencing arguments in nonviolent infractions. Finally, we arrive at Section 6, the definitive repeal. Chapter 20, Section 3581 is your absolute legal anchor here. It doesn't amend, it doesn't append, it mandates the total and complete replacement of the old code. The Indian Penal Code of 1860 will be repealed in its entirety, and the BNS will be imposed right in its place. So, as we transition from a 160-year-old framework to this modernized 358-section code, how are you going to adapt your legal strategies for your next trial? I really hope this explainer has equipped you with the precise structural insights and statutory shifts you need to navigate this whole new era of Indian law. With new definitions for terrorism, strict mandatory minimums for crimes against minors, and an entirely reorganized statutory architecture, the rules of the game have profoundly changed. How will you pivot your arguments, your evidence, and your trial strategy to master the Bharatiya Nyaya Sanhita? Thanks for joining this executive briefing, and we'll see you next time.